Hey everybody, Jonas Callis here of the Heard at Work workers' compensation law firm. Many of you know me as the workers' comp guy. First, the obligatory disclaimer. The following information is for informational purposes only. It does not constitute legal advice to anyone, nor does it create an attorney-client privilege with anyone or relationship with anyone. In this video, I wanted to discuss something that's common in workers' compensation claims. And in fact, it's common in all types of litigation. It's very little litigation that goes on that doesn't have discovery, okay? And it can be confusing to injured workers because the workers' compensation claims are supposedly designed for injured workers to be able to handle on their own, right? So if you don't have legal training, then how is an injured worker supposed to know about and understand how discovery works? But in any event, so what I want to talk about today to kind of help injured workers maybe understand that better and maybe even utilize discovery to help their cases. I'm going to talk about discovery, legal discovery, also called PreTrial Discovery. Now, discovery is a fairly common term. It's fairly common in the English language. People use it almost every day, I feel like. And so I think that's part of what leads to it being kind of confusing. But in the legal context, and discovery kind of means a similar thing in the legal context, but there's more of a formal definition to it, if you will. And that it just refers to a process or processes available to the parties involved in a legal dispute, such as a disputed and denied workers' compensation claim, to gather facts and documentation that is relevant to the pending litigation. So, and I've heard people talk about, there's informal discovery and formal discovery. I'll be talking about formal discovery today. Informal discovery isn't necessarily a thing. It's just, it's basically everybody investigates an accident. If they have an accident or something, they may investigate it to some extent. They may take pictures of it. They may speak to any witnesses or speak to an investigating police officer if, for example, you have a motor vehicle accident, right? So knowing who the witnesses are and knowing what facts there are, photographs, surveillance videos, whatever, right? That's kind of informal discovery. It's just your own personal investigation, what normal people do when they're involved in something that's out of the ordinary, like some sort of accident, okay? I'm going to be talking about formal discovery because in addition to the whatever informal investigation that people do just by being people, the rules of the Workers' Compensation Commission and also the rules of the Supreme Court of Virginia allow for actual formal discovery processes to help parties to a litigation actually request information, documents, et cetera, because what happens in an informal investigation? Well, somebody's at fault and they know they're at fault. They may just clam up. They may say, well, you're probably going to sue me, so I'm not going to tell you anything, right? And you can't make them right then and there tell you anything necessarily, right? But what formal discovery does is it allows you to ask them, and then they're kind of duty-bound to tell you, okay? So that's why it's important. When does discovery or pretrial discovery happen? Well, as you can tell from the name, it happens before trial, right? Before trial or hearing. Now, this is a little unique in the Virginia Workers' Compensation Commission, though. In regular court, parties get one bite at the apple, okay? So there's one trial or hearing, so anything pre that trial, right, is pretrial discovery, but there's only one round of it. Contrast that against the Virginia Workers' Compensation claim. If a worker wins entitlement to benefits, he or she would get to maybe at some point later, if her or his circumstances change, she or he may request additional benefits or different benefits, okay? Well, that request would be referred to a hearing docket. Then you have another trial set, right? Well, that allows for another series or another round of pre-trial, pre-hearing discovery, right? Or say the injured worker has an open award order for ongoing temporary total disability or temporary partial disability benefits. And the employer thinks it has a reason to suspend or terminate those benefits. The employer may file an employer's application for hearing, which probably will be docketed for hearing, right? In which case, PreTrial Discovery would ensue, right? So there can be multiple rounds of discovery, PreTrial Discovery, in the Workers' Compensation Commission. It's important to know that. So we kind of talked about this, but just to be more succinct, what are examples of when formal discovery may be utilized? After the claimant files an initial claim for benefits, right? We talked about that. After the claimant files a change in condition claim for benefits, we talked about that. After the employer has filed an employer's application for hearing, we talked about that. Here's one we didn't talk about. If the injured worker has an award, the accident or whatever has been deemed compensable, and say the accident was caused by a third party, right? Good example. Say there's a kind of a road construction company working on improving a road or whatever, maybe putting in a roundabout, and there's a flagger person, right? Well, say somebody comes along drunk in their car, hits the flagger, okay? Well, for the flagger, that's a workers' comp claim, right? They were doing their job flagging and somebody not related to their work at all hit them. So for them, it's a workers' comp claim, okay? But in addition to that, because that third-party tortfeasor person who hit them with the car while drunk isn't or wasn't related to their work, right? They may have a third-party lawsuit against that person in like circuit court, okay? So they can use discovery to try to gain information about that, right? Any statements that were made or taken, any photographs of that person, damage to their car, whatever, right? You can discover that as well. All right. So why is formal discovery important in Virginia workers' compensation cases? It serves several purposes. They're kind of common sense. I feel like you probably already know them. As I go through them, you'll probably be like, well, of course. First and foremost, it generally prepares the parties for trial. Of course it does, right? It gives you information and documentation that you didn't have. You're certainly in no worse position than you were before you conducted formal discovery. It also helps the parties to better understand the opposing party's position, right? I.e., the injured worker can actually ask the employer, what are your defenses to my claim? Like, are you disputing and denying the claim? Why? Right? What state the facts why? Okay? So it helps you understand where they're coming from and maybe where you need more evidence. Another reason, to prevent trial by ambush. In a lot of in Virginia courts and in the commission, there are discovery tools available. But in one Virginia court, the General District Court, there's no discovery. Okay, so you kind of you don't know what the other side is going to prevent. You don't know their evidence. Well, I should say that there's discovery. It's very minimal though, so you really don't know what the other side is going to present at trial. So it's kind of a trial by ambush, right? The discovery tools in the Workers' Compensation Commission exist to prevent trial by ambush if the party uses them. Another reason, it facilitates possible settlement of the claim by the parties once they understand the strengths and weaknesses of their claim and in their position and the strengths and weaknesses of the other side's position, right? It may lead to settlement. So, what can be discovered? Well, this is it's not, you're going to be like, why did he even say that? But I feel like I should say it because it is the standard, but it's not very helpful. Things that parties can discover by using formal discovery are information and documentation that are relevant or that are reasonably calculated to lead to the discovery of admissible evidence. And that's pretty much it. That's the standard, right? So as you can imagine, because it's kind of vague, it can lead to a lot of arguments. Not so much the relevant part, but whether something's reasonably calculated to lead to the discovery of admissible evidence, right? But in any event, you should know that because people shouldn't be asking you about, I don't know, about your certain private things, maybe if it's just completely not relevant to the claim. Okay, so with all that background, right? What specific types of formal discovery are there? What tools are there to get this information and documentation that I've been talking about? Several discovery tools. And remember, it's important for the injured worker because whenever the injured worker is requesting benefits, like workers' comp benefits, it's the injured worker's burden to prove her or his entitlement to those benefits. You need the evidence, right? So, interrogatories. What are interrogatories? Interrogatories are written questions served by one party on the other. The other party that receives them must answer them under oath within 21 days. Under the Workers' Compensation Commission's rules, each party may serve no more than 15 interrogatories on the other party at any time or cumulatively actually, without prior leave of the commission, without prior permission of the commission to do so. Interrogatories are often used to kickstart a party's investigation. You can, like I said earlier, you can find out the reasons why the employer is denying the claim. You can find out about if they're contesting the reporting, like whether it was timely reported to them, or the actual accident itself. You can find out about any information about medical treatment or wages or anything like that. In addition, this is important, you can find out the identity of witnesses and what they know or what they purportedly know that the employer's defenses are based upon, right? Like, they're denying the claim for some reason. They got their information from somewhere. Where'd they get who gave them that information, right? So you can find that out. And that information often leads to discovery depositions, right? Well, I'll talk about that in a minute. All right, next discovery tool, requests for production of documents and things. It's actually what it sounds like it is, okay? It's a common discovery tool in Virginia. Workers and all parties, any party can discover from the other party documents, tangible things, medical records, videos, surveillance videos, photographs, witness reports, accident reports, things like that are relevant to the pending claim. In contrast to interrogatories, where there's a limit of 15 without prior permission from the commission, there's no limit to the request for production of documents, except for, obviously it has to be relevant or reasonably calculated to lead to the discovery of admissible evidence, but and maybe not violate like certain privileges, which I'll talk about in a minute. But otherwise, you can get a lot of documents and tangible things that can help you better understand the strengths and weaknesses of your claim. The next tool, depositions. Again, another common discovery tool. If you've seen our website and if you've seen our other videos, you probably know a lot about depositions already. It's just it's an under oath, out of court question and answer session conducted by an attorney usually, but if you're proceeding on your own without an attorney, like for example, you could depose somebody else. You can ask the questions and they have to give you under oath answers. The deponent, the person being deposed, has to answer the question under oath, honestly, right? Unless they don't know. I mean, sometimes people don't know and they can say, I don't know, if they truly don't know. But that it's a good way to get information and find out what people know. The depositions are typically transcribed by court reporters. Depositions of the claimant and of physicians are required to be filed with the commission. And typically what they're used for, deposition transcripts, is they're used to impeach the credibility of a witness, say at trial, right? To the extent that that witness is testifying, saying something at trial that's different than that witness said under oath at a deposition, right? It's like, why the inconsistency, right? So it makes that witness seem less credible if the story's all over the place, right? This is important, pursuant to 65.2-703A of the Code of Virginia and Rule 1.8 of the Rules of the Workers' Compensation Commission, any party to a workers' compensation claim may take the deposition of witnesses to that claim, regardless of whether the witness lives in state or out of state, right? If they're not in Virginia, you still have the right to take their deposition. And parties are, a witness, the term witness is construed broadly. It can include like an insurance claims adjuster. You can actually depose an insurance claims adjuster if the deposition, if her or his testimony is needed and relevant to the claim. If there's nothing that they can offer, you may not be able to depose them. But it's there. Now, parties, we'll talk about subpoenas in just a minute, but a party can compel a witness's attendance at a deposition or a trial with the use of a subpoena. Typically, there's no need to get the commission's permission if you're going to depose a party or a physician. However, if you're trying to depose someone else, like some other witness, probably have to get the commission's permission first. And it's noteworthy that although the parties can depose any witness, whether they're in state or out of state, you may run into problems if the witness is, like, say, for example, lives in South Carolina. Because there may be constitutional issues by issuing just a Virginia subpoena. to someone in South Carolina. They'll probably just ignore it, I think. But Virginia has adopted a form, a version of the Uniform Interstate Depositions and Discovery Act, often referred to as UYEDA, which sets forth procedures for litigants to pursue out-of-state discovery. Okay, so in Virginia, Section 8.01-412.10 governs the issuance of witness subpoenas for witnesses located outside of Virginia. Now, without getting into too much of the details of that, suffice it to say that going through a UYEDA can take a bit more time and also can be more expensive. So, but I'm not sure that there's another way to go about it. Really, like if you get called on it, you're best off using UYEDA and preparing in advance because it can take longer. All right, next discovery tool, subpoenas. These are important. All interrogatories, requests for production of documents, that's geared towards the other party in the claim, like employers and workers' compensation insurance company. Subpoenas are more geared towards non-parties more. It is a valuable tool because you can subpoena somebody for a deposition, right? You can subpoena them to get their testimony, what they know. You can also subpoena somebody, you can issue a certain subpoena to get documents and photographs and surveillance video and things like that. So from non-parties, right? So that's why they're so important. What is a subpoena? I feel like I need to discuss that first because I think a lot of people know the word, they've heard the word, but they're not quite sure what it is. A subpoena is a writ issued for our purposes by the Workers' Compensation Commission or by like a Virginia court, like a circuit court maybe, to compel testimony by a witness or to compel production of evidence, documents or whatever, under a penalty for failure to do so. Okay. In fact, the word subpoena actually comes from two Latin words, sub and pena. Okay, which literally means under penalty. So a subpoena is simply an order of the court or the commission commanding someone or some entity to do something where a failure to do that thing could result in some sort of penalty or sanction being imposed against that person or entity. So where a regular subpoena, or often also called a witness subpoena, compels a person to be somewhere to give testimony, like you can subpoena somebody to a deposition, you can subpoena somebody to the trial or hearing. A subpoena duces tecum is a subpoena that orders somebody in possession of relevant documents or things, medical records, photographs, surveillance video, whatever, to produce those things by a certain time and date at a certain place for the person who issued the subpoena for their review. Okay, so those are valuable too. Obviously, it helps build your knowledge of the case and what you're up against, and strengths and weaknesses of your case. The party requesting the issuance of a witness subpoena or subpoena duces tecum must prepare the subpoena and then submit it to the commission along with payment for service of the subpoena. The commission will then forward the subpoena and the service fee to the designated sheriff's office for service. There are time limits for filing requests for subpoenas with the commission. Pursuant to Rule 1.8, if requesting the issuance of a subpoena through the commission, the request should be filed at least 10 days prior to a hearing if it's a witness subpoena, and at least 15 days prior to hearing if it's a subpoena for documents and things. Additionally, pursuant to other Virginia law, and this is important, potential witnesses must be served with a witness subpoena at least 5 calendar days prior to the time their appearance is required. Otherwise, the subpoena might not be enforceable due to lack of adequate notice. Similarly, subpoena duces tecum for documents and things must be served at least 14 days prior to the date that the compliance is requested. Otherwise, it could be successfully objected to for the same reasons. All right, last discovery tool. This is an important one. I think it's underused. Requests for admissions. I think it's underused in the Virginia Workers' Compensation Commission and in regular courts, but they can be powerful. A request for admission is a written request for the admission of the truth of any material issue. In other words, it's a suggested statement to the other party, which the other party generally must admit or deny. Requests for admissions are used to confirm certain facts so that the parties can determine what is agreed upon and what is still disputed and needs to be worked out going towards the trial or hearing. Another thing, requests for admissions can be used to confirm the authenticity of certain documentation. If you can attach the documentation and request the other party do that, like exactly that, confirm that this is an authentic blah, 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 it'll avoid the need to have to produce witnesses or whatever to testify at the hearing to authenticate those documents. So that's a useful tool for that as well. Interestingly, the Workers' Compensation Commission does not limit the number of requests for admissions that can be propounded or served upon another party. However, Rule 4:11 of the Rules of the Supreme Court of Virginia somewhat recently was amended to limit the number of requests for admissions to 30 for any given matter. So now, that said, 30 is a lot of requests for admissions. Workers' compensation issues are typically fairly narrow, so there really shouldn't be a need to exceed 30. Just an FYI. Now, what does it mean to have a request for admission admitted? Well, the fact contained in a request for admission, if it's admitted, it's an admitted fact for that proceeding, right? So that's why they're used to confirm the facts and narrow the issues, all right? Now, that's important to understand because a party is required to respond to requests for admissions within 30 days. What happens if the party fails to respond timely? Well, the other party can move to have them, the request for admissions deemed admitted. And a lot of times the courts do it without hesitation, and the commission will do it as well. And what that means is everything that the other party has stated in those requests for admissions will be deemed admitted for the trial. And quite often that means that the other party has basically just admitted away their case. So they're basically going to lose. So you have to timely respond to requests for admissions is the takeaway. So the last issues I wanted to touch on today are what I consider 3 common questions in workers' compensation discovery issues. First, do injured workers have to answer discovery requests sent by the employer and their insurance company? Yes. If you've been paying attention, you know that now that yes, you have to respond. They have to respond to yours. You have to respond to theirs. 4 reasons, right? The first one, these are rules. It's formal discovery. It's rules. It's discovery that's available to be used by everyone. So you can use it, injured workers, and employers and insurance companies can use it. So it's just a fairness issue, first of all. Second of all, the commission can actually dismiss a claim for benefits or claims for benefits. And it can also strike employers' defenses if they're the ones. But if a party fails to completely respond to discovery, basically just ignores it, especially if the commission orders them to respond, then the commission can actually dismiss the claim or strike the employer's defenses, making the claim compensable. So that's a drastic measure, but it happens. Third, even if the commission does not dismiss a claim, as we just discussed, to the extent a party fails to timely respond to requests for admissions, all those will be deemed admitted, and usually that's a bad thing for the party that failed to respond, okay? A lot of times it can cause you to lose your case. Final reason, the commission has the authority to exclude evidence that had been asked for in discovery and not provided in response to discovery, all right? This is kind of what we referred to earlier as trial by ambush. The commission doesn't want trial by ambush. That's the whole point of having discovery. So to the extent you or the employer fails to say something or tell you something in discovery that you've asked for, and then they want to use it at the hearing, even though you asked for it and they kind of kept it hidden, they probably will not be able to present it at trial, nor will you if you do the same thing. The next common question, is there any way to limit what I have to disclose in response to the employers and insurance companies' discovery requests? Yes, somewhat. If you visited our website, seen our other videos, you're probably aware that some attempts to gather information specifically by the insurance company claims adjuster is voluntary, right? I'm thinking of recorded statements here. If it's not required by law, then it's voluntary. Well, if it's voluntary, you can decline to do it, right? You don't have to do a recorded statement. So that's one way to limit their discovery, right? Also, sometimes insurance claims adjusters will ask workers to fill out Releases, right? For example, a medical record release form. A lot of times these are phrased very broadly, right? And sometimes, obviously, since injuries and health condition are at issue in a workers' compensation claim, the insurance company will certainly be entitled to a lot of medical information. But depending on the injured worker's medical history and treatments and stuff, maybe not all the medical evidence is discoverable, right? And that not only medical, it doesn't just apply to medical issues, but also other issues. So injured workers should be sure to check the language contained in the release, whatever release it is, to make sure it's not overly broad and kind of reaching too far, right? Also, if the discovery requests are excessive or invasive, an injured worker can file a motion for a protective order, asking that discovery be limited. The Commission has the authority to limit the frequency and extent of discovery if they deem it unreasonably cumulative, duplicative, or expensive. To determine that, the Commission will review the nature and importance of the contested issues, the parties' resources, and whether there is a more convenient and economical way to obtain the requested information. If good cause is shown, the Commission will, in fact, enter a protective order to limit discovery. And usually the protective order is entered to protect a party or witness or some other entities from embarrassment or oppression or undue burden or expense. Injured workers may also seek a protective order to protect confidential information. So say you settled a prior workers' compensation claim or lawsuit. You can file a and they want that information, right? You can file a protective order since you've already agreed in that settlement, as part of that settlement, it's standard to agree to confidentiality agreement. You can move for a protective order and then let the Commission sort out whether it can be discovered at all, and if so, how much is discovered and what happens to the discovered information. Now, obviously, as we've discussed, all discovery has to be relevant or reasonably calculated to lead to the discovery of admissible evidence, assuming it meets that it's a fairly low bar, right? Certain privileges may apply to allow parties to withhold other information or documentation. The easiest way to describe that is just to talk about them, I think, because most everybody's heard of them. The first one, for example, attorney-client privilege. Communications with your attorney, both oral and written, are privileged and typically doesn't have to be disclosed. Another one, attorney work product. The other party may not discover or obtain any document made in preparation of litigation. They can't discover the attorney's opinions or strategy related to the claim. It kind of makes sense, and that typically holds up. Spousal privilege. Spousal privilege is still tried and true, still stands in Virginia. Now, here's a ninja tip though. A lot of time, and like think of it this way, think of like a head injury, right? Traumatic brain injury. A lot of times the best evidence for a traumatic brain injury for the injured worker is the injured worker's spouse, right? The injured worker's spouse will be able to say, yeah, such and such used to pick up the kids every day from school. I can't even trust him to do that now because he never remembers it. He always forgets it. Like I remind him 20 times a day and he can't remember. He can't tie his shoes anymore. Things like that, right? Injured workers if they are having those memory issues, they may make a lousy witness on behalf of themselves, but the spouse may make a great witness. So a lot of times the spousal privilege is actually better. I mean, you can use that to your advantage as an injured worker. Mediation privilege. Some claims go to mediation, sometimes for to try to settle it. Other times it'll go to mediation for kind of an issue where there's a disputed issue. They try to get the parties just to agree upon some sort of middle ground. Memorandum, documents, statements made during the mediation, they're all privileged. They can't come in as admissible evidence and they're not discoverable, okay? Now, that said, the underlying facts that those memorandum or statements are based upon, those underlying facts are still discoverable, right? And probably most of the time they've already been admitted in discovery. So it's an important distinction. Lastly, privilege against self-incrimination. I plead the fifth. We've all heard this, like in movies and old reruns of Law and Order. No person can be compelled to give information or to produce documents that incriminates them in a separate criminal trial. And you're probably thinking, Jonas, this is a workers' compensation claim. How would that even apply? Well, say an employer alleges that the injured worker sustained the injuries when they attacked someone else, right? I mean, that could be criminal type of implications there. Or maybe a better example is maybe the employee's delivery driver, right? And the employee's gross negligence or recklessness, maybe they just made bad decisions driving, caused an accident, and maybe there are criminal charges pending against him or her, right? So it's rare that it comes up, you're right. It's rare that it comes up in workers' compensation cases, but they can be applicable. So now, the last thing about that. Any party claiming privilege and withholding information or documentation pursuant to some privilege must provide a privilege log wherein they generally identify what's being withheld and also the privilege, like why it's being withheld. Obviously, if you disclose too much, it defeats the purpose. So you don't want to tell, it doesn't need to be too detailed, but you have to provide enough detail to where the other opposing counsel and the judge will be able to look at it and say, yeah, that's privileged, or no, you need to produce that. Just so we're clear, I did not forget doctor-patient privilege, okay? In workers' compensation claims, the thing that's at issue a lot of times is injuries and the extent of injuries and health condition and this, that, and the other, okay? So actually, HIPAA and doctor-patient privilege does not apply in workers' compensation claims in Virginia. All right, so that's number 2 of the third common type of question. Or number 2 of 3. The third common question is, can I change my initial answers to discovery, and or do I have to change my initial answers? Short answer is yes and yes. Obviously, all parties have an ongoing obligation to provide current and accurate, not misleading discovery responses. So to the extent you've provided accurate responses in the past, but something changed, your understanding changed, you do have to update that and keep your answers current. Why? We've kind of already talked about it, right? There are consequences. If you're going into the trial and your discovery responses are inaccurate, to the extent you try to offer other evidence that is inconsistent with your discovery responses, right? The whole trial by ambush thing, right? The commission may exclude that evidence. You don't want your evidence excluded. So you have to constantly update your discovery responses. Also, the judgment, whenever somebody seems to be being kind of shady with their answers or whatever, it seems like they're trying to hide something. You don't want the administrative law judge, the deputy commissioner, because they're the jury and the judge, right? They decide, they determine the outcome of the case. You don't want the judge, the administrative law judge or deputy commissioner, to think that you're hiding something or being dishonest. So that's about all I wanted to discuss today about legal discovery or pretrial discovery in the Virginia Workers' Compensation Commission. I hope it's been helpful. Thanks for watching. There's more information on the website and in other videos. Check out the website at www.hurtatworkinva.com. That's www.hurtatworkinva.com. Also, follow us on YouTube, Facebook, Twitter for other information and updates. The whole point of this is to provide information, right? I'm trying to do my part to get information out there. Now I need you guys to spread it and say, look, go to this site. It's got good information. It'll help you know what benefits you might be entitled to and how best to pursue those benefits, okay? And if you find this video or other videos or our website helpful, pass it on, right? Tell your friends and family, because that's how we can get the word spread and make sure people are getting the workers' comp benefits to which they're entitled. I think that's all I got. Until next time, stay safe and don't get hurt at work.